Not through the front door, but through a loophole in legislative language. That was the opening line on CNN at 3:47 a.m. when leaked footage first aired. Camouflage-clad federal enforcement agents disembarking from unmarked military trucks under the hazy streetlights of South Central Los Angeles. No governor's approval, no state emergency, no official explanation. Just boots on asphalt and silence from the Capitol. Inside the California State Capitol, Governor Gavin Newsom stood motionless, phone pressed to his ear, listening to a Senate liaison relay what he had already feared. "They've landed," he asked, jaw clenched. "They've been operational for 4 hours," came the answer. 4 hours? By the time rumors reached the people of California, the operation was well underway. And when Newsom hung up, he didn't reach for coffee. He reached for the Constitution. 1:14 a.m., secure line. California Attorney General Rob Bonta picked up on the second ring. "Gavin, this isn't deployment," Bonta said flatly. "It's a breach." "A breach of what?" "Our laws, our rights, our damn statehood." There was no televised address, no public clarification from the White House, because this wasn't a presidential order. But there was a tweet. Oh, there's always a tweet. John Neely Kennedy. "California can't even keep the lights on, let alone manage its streets. If Newsom won't do his job, Congress will." Retweets exploded into the millions. And just like that, the chaos had a name. Hashed order from the Senate. Back on the ground, justification trickled in like military fog. A late-night memo from the Senate Oversight Committee, led by Senator Ted Cruz, cited ongoing civil unrest, failure to protect federal property, and an urgent need for stabilization. But the document named no acts of violence, no casualty reports, no formal request from local authorities, no coordination with California officials. "Sounds like a coup wearing a Senate badge," Bonta muttered as he skimmed the document. 2:22 a.m. Newsom signed a sealed emergency directive to the California Attorney General's office. One sentence written in his own hand and circled in red: "No senator gets to bypass the 10th Amendment. Not while I'm breathing." Meanwhile, the far-right media engine roared to life. Tucker Carlson praised the move as a brave reclaiming of constitutional order. ONN aired looping footage of trash fires from last year's protests. The narrative was being constructed, brick by brick, in real time. And Kennedy? He wasn't watching the reaction. He was orchestrating it. In a now-deleted Truth Social post, he wrote, "These states think they're sovereign. They forget they're just pieces on the board." 3:05 a.m., Sacramento. Bonta's team mobilized. Statutes were pulled. Precedent cases reviewed. A draft injunction was drawn up at record speed. Goal: a temporary restraining order to block the Senate-led federalization of the California National Guard and stop what Newsom now called an undeclared legislative invasion. A young legal aide turned to Bonta. "Sir, are we filing ex parte?" "Yes," Bonta said without pause. "Let them whine about process. We'll argue legality later." Right now they're smashing the glass. 4:17 a.m. The tension was no longer California's alone. It spilled across state lines. Rachel Maddow opened her segment with a chilling monologue. If a U.S. senator can mobilize troops into a state without consent, federalism isn't just endangered, it's dead. 5:33 a.m. San Francisco. Somewhere inside the federal courthouse, a system alert pinged. New case filed. State of California versus Senator John Neely Kennedy, Senator Ted Cruz, and the Congressional Enforcement Act. Presiding judge, Charles R. Brier, a name that carried weight in both judicial chambers and the Kennedy-Cruz block of Congress. A name that needed no introduction, not to the judiciary, not to the lawmakers, and certainly not to his brother, Justice Stephen Brier, the recently retired Supreme Court Justice who had warned just months earlier. The erosion of judicial independence doesn't begin with executions. It begins with compliance. Just months earlier, Justice Stephen Brier had warned publicly. The erosion of judicial independence doesn't begin with executions. It begins with compliance. Now his younger brother, Judge Charles R. Brier, was being asked to rule on a case that could ignite a constitutional civil war. Brier's clerk reviewed the request, a 22-page complaint from the state of California, demanding an emergency injunction against the actions of Senators John Neely Kennedy and Ted Cruz, citing violations of the 10th Amendment in the Administrative Procedures Act. One line stood out and read, "No armed force may override the sovereignty of a U.S. state in the absence of insurrection or invitation. Neither is present." But Brier didn't sign off, not yet, because 5 minutes later, a filing from Senators Kennedy and Cruz's legal team hit the docket. It wasn't a defense, it was a delay tactic, a formal request for 24 hours to respond. And Brier granted it, not because he approved of the actions, but because he was methodical, because he knew a rushed ruling could be torn apart on appeal, because he wasn't playing checkers. 6:12 a.m. First light broke over California. Newsom stood by the Capitol window, the sunrise spilling behind the dome. "They're going to say we overreacted," he said quietly. Bonta replied without looking up, "Good, that means we reacted." 2:03 a.m. California Attorney General's office, Sacramento. "Draft the TTRO," Bonta ordered. "We're not waiting for federal courtesy." An aide blinked. "Ex parte?" Bonta nodded. "Ex parte as hell." And with that, the legal war room snapped into motion. Screens lit up with statutory texts. Case law appeared like formations on a battlefield. The objective was clear: stop two senators from weaponizing Congress against the sovereignty of a U.S. state. By 11:00 a.m., the complaint had been officially filed in the federal docket. The charges were precise. Violation of the 10th Amendment. California's sovereignty had been trampled. Breach of the Administrative Procedures Act. The so-called Congressional Enforcement Directive had bypassed procedural safeguards. One passage in the complaint read like a gavel strike. No American state has surrendered the right to self-governance to members of the legislative branch. This is not oversight, it is overreach. Bonta's signature stood firm at the bottom of the filing. Meanwhile, in Washington, D.C., the response was swift and murky. Inside a columned Senate office, Cruz's legal advisor went live on Fox News, dressed for a courtroom but performing for television. The Senate has constitutional oversight. Under its plenary powers, and in light of California's refusal to act, it authorized emergency stabilization measures. Senators Cruz and Kennedy merely acted where the governor failed. No evidence, no precedent, but plenty of volume. Pundits repeated the script like dashboard bobbleheads. If Governor Newsom can't secure his cities, Congress has not just the right, but the responsibility to intervene, one said. Back in California, Bonta saw the broader picture. "This isn't just about troops on the ground," he said. "It's about setting a precedent. If we lose here, it won't stop with California. Texas will be next, then New York, then any state that refuses to kneel." His deputy added drolly, "We're not filing a lawsuit, we're building a firewall." The assignment of Judge Charles R. Brier raised eyebrows. At 83 years old, a Clinton appointee, judicial veteran, and constitutional purist, Brier wasn't known for chasing headlines, but he was known for pausing when the Constitution was in peril. Whispers filled the courthouse. "Isn't he Justice Breyer's brother?" "Yeah, the one who warned against authoritarian creep last year." A murmur swept the halls. Destiny, it seemed, had a sense of irony. 11:27 a.m., San Francisco Federal Courthouse. Judge Brier read the filing carefully, line by line. Then he sighed. "Ex parte," he murmured. The word lingered like the smell of overcooked politics. He tapped his pen. "Courts generally hate ex parte motions," he said to no one in particular. "They prefer full briefing, full context." He flipped the page again. "But it's not every day the legislative branch attempts to authorize boots on the ground. But it's not every day that members of Congress storm a state through legislation instead of boots, but with consequences just as real." Across the country, Kennedy and Cruz's legal teams filed their formal response. A request, a stall. They asked for 24 hours to submit a full brief. No fire, no fury, just paper. But Judge Charles Brier saw it for what it was, a delay disguised as due process. And yet, he granted it, not out of deference, but out of discipline. Governor Newsom received the update like a general reading battlefield weather. "They asked for time or surrender," he muttered. "Then we make damn good use of ours." 12:14 p.m. MSNBC. A commentator read aloud from the court documents. Plaintiff Gavin Newsom, on behalf of the state of California, filed an ex parte motion for a temporary restraining order at 11 a.m. on June 10th. Then came the line that made national blood pressure spike. Defendants Senator John Neely Kennedy, Senator Ted Cruz, and the Senate Oversight Committee requested 24 hours to respond. Judge Brier granted the request. The camera cut back to the anchor. Looks like the judge doesn't want a fast fight. He wants a full one. Inside a coffee shop in Berkeley, a law student muttered into her laptop, "This is Bush v. Gore, but with congressional boots." 1:32 p.m. Legal forums exploded with debate. Some praised Brier for respecting due process. Others accused him of giving Congress time to solidify their grip. But one line, buried in an op-ed by a retired judge, rose to the surface. Emergency orders should be rare, but when enforcement is already on your streets, delay isn't justice, it's surrender. 4:46 p.m. California State Capitol. Rob Bonta's legal team gathered around a whiteboard filled with citations. "We need to hammer the 10th Amendment," one advisor said. Another added, "And the APA, their procedure was a joke. No review, no record, no accountability." Bonta nodded. "Then we bury them in logic. If they're going to use congressional power like a megaphone, we'll use the Constitution like a sledgehammer." 8:01 p.m., Washington, D.C. Congressional press room. A reporter stood up and asked, "Senator Kennedy, California claims you've overstepped constitutional bounds. Any response?" John Neely Kennedy leaned into the mic. "They said I couldn't stand up to radicals. I did. They said I couldn't bring law back to lawless states. I did. Now they say I can't protect this country? Watch me." Thunderous applause from his base. Smirks from Cruz and others standing behind him. 11:59 p.m. Sacramento. Rob Bonta signed the rebuttal brief. He placed it on the desk and said to his clerk, "This goes in at 9 sharp." He looked out the window. A patrol car hummed in the distance. Helicopters buzzed above the skyline. Troops, activated under legislative pretext, remained deployed. But the law was moving too. Across the city, the courthouse prepared. The hearing had a time, 1:30 p.m. The country had a clock, and Judge Brier had a decision. June 12th, 1:26 p.m., San Francisco Federal Courthouse. The hallway outside courtroom 6B was packed. Journalists with hot mics, clerks whispering citations, one pundit live streaming from the stairwell like it was a moon landing. Inside, the air felt electric. Cameras weren't allowed, but every seat was filled. Because what was at stake today wasn't just congressional overreach. It was the reach of federal power itself. It was the endurance of the Constitution. 1:30 p.m. sharp, Judge Charles Brier entered the courtroom. No smile, no hesitation, just his voice. "This court is now in session. Matter, State of California versus Kennedy Cruz et al. Let's proceed." Senators' legal counsel stood tall, well-pressed, calm, and radiating the entitlement of constitutional interpretation on their terms. "Your Honor," the lead counsel began, "Senators Kennedy and Cruz acted within the bounds of legislative oversight, under the provisions of congressional emergency authority and in accordance with the stabilization mandate. When a state fails to restore order, Congress not only has the right but the duty to act." Judge Brier raised an eyebrow. "Insurrection? Has one been declared?" "No formal declaration, sir," the attorney conceded. "But the facts on the ground, burned vehicles, attacks on property, constitute insurrection by implication." The gallery murmured. Somewhere in the back, someone scoffed audibly. Rob Bonta rose slowly, calm, composed, razor-edged. "Your Honor, there has been no insurrection, no formal request for federal assistance, no escalation beyond what local law enforcement can handle. What we've seen is unilateral congressional intrusion. That's not protection, that's occupation." The senator's lawyer leaned forward again. "If California's sovereignty becomes a refuge for lawlessness, then the federal government, acting through its legislative authority, must intervene." Bonta didn't blink. "We do not harbor lawlessness. We defend constitutional boundaries, the same ones that keep this chamber from turning into a throne room." Judge Brier steepled his fingers. I don't care if you call it rebellion or resistance. What I want to know is, who decides that? You or the Constitution? Silence, the kind that tastes like iron. The Senate's legal team tried again. The federal legislature cannot sit idle while a state crumbles. Bonta responded with steel in his voice. California is standing. What's crumbling is the balance of power, when a handful of senators move authority like chess pieces. A junior associate at the defendant's table tried a new line. Your Honor, the Administrative Procedure Act doesn't apply during emergencies. Bonta replied before Brier could. Then declare one. Call a national emergency and invoke the War Powers Framework. But don't sidestep the process and pretend the Constitution is optional. Brier nodded slightly. That's a fair distinction. 2:07 p.m., recess. The courtroom buzzed like a disturbed hive. Reporters scrambled to file quotes. MSNBC aired a montage of past congressional overreach. OAN ran a chyron. Kennedy defends the Union. California cries wolf. In the hallway, a TV played an old interview. Justice Stephen Brier, seated calmly, said with weight, the judiciary must stand. If not for justice, then at least for the memory of what justice used to mean. Inside the courtroom, Judge Charles Brier stared into the distance. He'd heard the quote before, but today it felt heavier. 2:21 p.m., court back in session. Judge Brier tapped the bench with quiet force. I have reviewed the filings, listened to the arguments, and studied the statutes. This court recognizes the gravity of federalism, and it also recognizes abuse of discretion when it sees one. Senators' counsel stood, ready to object. But Brier cut him off. Sit down, counselor. You'll get your appeal. The courtroom held its breath. This court finds that the deployment of federally mandated forces into California, initiated through congressional overreach, was done without statutory authority, without coordination, and without factual justification. It constitutes a breach of constitutional balance. And that breach stops here. Gasps rippled. One journalist mouthed, "Holy shit!" Bonta turned to his team. No celebration, just nods. Just breathing again. The temporary restraining order is granted. Further federal enforcement presence is hereby restrained. Any ongoing activity must cease unless renewed through a coordinated, legally authorized framework. Then came the line that would be quoted across the country. This court does not answer to chaos, it answers to law. Judge Charles R. Brier returned to the bench, bringing with him the gravity of precedent and the full weight of a constitution far too often treated like a brochure. The courtroom stood still, not with ceremony, but with the silence that falls when everyone knows they are standing inches from history. He adjusted his glasses, cleared his throat, and without raising his voice, dropped it across the chamber like a gavel. This court does not serve senators. It serves the Constitution. A cough in the gallery, no other sound. The use of federalized enforcement without cause, without consultation, and without evidence violates the very core of the 10th Amendment. He paused, then continued. Let me be clear, a legislature may respond to a national emergency, but it may not manufacture one. The Senate's lead attorney stood, face tight. Your Honor, if I may. Brier didn't blink. No, you may not. Sit down. The room locked into place. This court finds that the deployment of federally authorized enforcement personnel into the state of California was carried out without statutory foundation, without factual justification, and in direct conflict with the procedural standards outlined in the Administrative Procedure Act. It was not an act of national defense. It was legislative overreach masquerading as public safety. He let the silence land. Then, accordingly, this court issues a temporary restraining order, effective immediately. Any further deployment of federal personnel into California is barred unless it occurs under explicit legal coordination and validation. All currently deployed agents must stand down and withdraw, unless reauthorized through proper federal-state channels. Rob Bonta exhaled slowly, not in relief, just in confirmation that the walls of reality had held. A clerk leaned toward a reporter and whispered, he actually said it. Brier wasn't done. Furthermore, this court directs the Department of Justice to issue immediate notification to all relevant federal entities regarding the scope and binding authority of this ruling. And let the record reflect, if this breach is tolerated, there may not be many state boundaries left to defend. The courtroom didn't erupt. It exhaled. The senator's team scrambled. One aide passed a phone across the table. Another typed furiously. Their lead counsel stood once more. We respectfully file immediate notice of appeal to the Ninth Circuit. Brier nodded once. You're welcome to it. The law welcomes scrutiny. Outside the courthouse, the headlines were already everywhere. Brier strikes down, congressional invasion. Judicial earthquake in California. San Francisco to Capitol Hill. Get your laws off our lawn. 10 minutes later, Washington, D.C. Senator John Neely Kennedy stood on the Capitol steps in front of a hastily arranged press setup. American flags framed his shoulders, some hastily ironed, most staked more for optics than substance. He leaned into the mic. Judges don't defend the nation. Senators do. He stared straight into the camera, chin tilted with defiance. But the fire was dulled. This was a weak ruling, a political stunt by a Clinton appointee. It won't last. Reporters shouted over each other. Senator Kennedy, will you comply with the order? He smirked. I don't lose. I just recalibrate. Back in California, Rob Bonta stood outside the courthouse, surrounded by reporters and staff. His words were steady, measured, not celebratory. Today's ruling wasn't just about federal intrusion. It was about boundaries, legal ones, constitutional ones, human ones. When lawmakers forget those lines, it's the courts that must remind them. He turned to his team. We didn't beat senators. We restored a line. Inside, Judge Brier lingered at his bench a while longer. He watched the courtroom slowly empty. He noticed the blank notepad on his desk. Then quietly, to no one in particular, he spoke. Law isn't loud. It just lasts. Law isn't loud, Brier had said. It just lasts. By nightfall, the San Francisco courthouse stood quiet, but the digital world did not. Hashtags tore through timelines like wildfire over dry California hills. # Brier verdict, #Kennedy, Cruz overreach, #Justice draws. A line CNN ran the chyron. Justice draws a line. We will not go back. MSNBC went harder. 2 senators tried to militarize a democracy. 1 judge made sure it stayed one. Fox News hit back, a political ruling masquerading as constitutional law. Outside, camera crews lingered on the empty steps. A few protesters stood with signs. Others lit candles along the sidewalk in solemn rows. Someone, young, angry, poetic, spray-painted across the pavement in bold black letters. Justice didn't shoot. It simply stood its ground. Back inside the California Department of Justice, Rob Bonta faced the cameras, without a hint of arrogance, despite the magnitude of the win. We didn't take them down, he said, his voice firm. We just lifted the truth high enough for everyone to see it. He paused, then added, this wasn't about power, it was about limits. Meanwhile, far from the courthouse, at his golf club in Texas, Senator John Neely Kennedy stood flanked by 2 flags and a banner reading, Law and Order, the real version. He stepped to the mic. Judges don't win wars, he snapped. Senators do. I'll keep fighting for this country, even if that means fighting activist courts and fake lawsuits. He didn't take questions. Clips of his statement ran on loop for the next 48 hours. Some networks spun it as resilience, others as desperation. Then, around 2:00 a.m., a clip reemerged, tweeted by a journalist from The Atlantic. It was Justice Stephen Brier, long retired, speaking with quiet force. When one judge speaks the truth, he speaks for the silent majority of the Constitution. The video was short, haunting, and by morning, viral. Think pieces erupted across the nation. The New Yorker ran a cover, a golden-hued courtroom, one judge's bench casting a long shadow over a pair of combat boots. The Washington Post headlined, "A Gavel Against the Gun." Panels formed from Berkeley to Yale, analyzing Brier's ruling not just for its legal logic, but for its symbolic defiance. The Constitution is not a suggestion, it is a structure. No rebellion was declared, no insurrection was evident. What was clear was the ambition of one. They underlined those lines in red. While pundits battled over ideology, the public absorbed something more lasting. This wasn't just California versus Kennedy and Cruz. It was law versus appetite, limits versus momentum, a gavel versus a gut instinct to conquer. It was the story of an 83-year-old man in a black robe who didn't blink. He didn't campaign, he didn't shout, he didn't grandstand. He wrote it down, and that was enough. Enough to stop the storm, enough to call the bluff, enough to remind the country quietly, precisely, constitutionally, what lines still mattered. Outside the courthouse, the candles stayed lit through the night, not in mourning, but in memory.